Good morning, everyone, and welcome to our session today of the UK Trade and Business Commission. It's a very important session today. We're considering the implications for business and the constitution of the bill currently in Parliament concerning the potential revocation and reform of EU retained law. As we normally do, we're going to divide today's session into two halves. In the first, we'll be considering the implications for business, and in the second, we'll be considering the constitutional fallout from this. Let me start by asking our first panel of witnesses, to whom many thanks for doing this with us, to introduce themselves. Simon, would you like to go first?
Yes, my name's Simon Joyston-Beckel. I'm a solicitor, regulatory defence solicitor, so I look after organisations that are being criminally prosecuted for breaches of the sort of regulations that we're discussing. My focus is on safety. I previously qualified as a doctor, and so my legal advice is related to safety, and that's the relevant safety rules today.
Thank you very much, Simon. Rosa.
Hello, thanks very much for the invitation to give evidence. I'm Rosa Crawford. I lead on international trade and Brexit policy at the Trades Union Congress. That's the National Trade Union Centre of the UK, representing 48 affiliated trade unions and over 5.5 million workers.
Thank you, Rosa. And finally, William.
Good morning, everyone. I'm William Bain, the Head of Trade Policy at the British Chambers of Commerce, representing 80,000 small and medium-sized businesses in membership of 53 accredited chambers of commerce across the UK.
Thank you very much. Let's now turn to the first question. And just before I do, I will be keeping an eye on the clock because we have a lot to get through. And if necessary, I'll need to impose a guillotine, but hopefully we won't need to do that. There's about 7 or 8 minutes for each question, I think. So the first question is really just to frame the rest of the discussion. Could I ask each of you in turn to give us your thoughts on how, if this bill passes, your particular constituencies or sectors will be affected, and which areas of legislation will be most affected by the changes proposed? Rosa, would you like to go first?
Yes, sure. So as you may have seen on the front page of the Financial Times this morning, the TUC businesses and civil society groups have written to the BEIS Secretary Grant Shapps, highlighting concerns that this bill threatens to undermine fundamental rights, will create costly legal uncertainties, and threatens to breach the UK's commitments on level playing field under the Trade and Cooperation Agreement. And so for this reason, we and those other groups are calling for the bill to be scrapped. So if I could just highlight those concerns a bit more in detail. So on employment rights, the bill, as we know, will remove all EU-derived laws by the end of 2023. And we've had no indication that we will have workers' rights re-legislated for UK-specific laws. So we is therefore concerned that this puts a whole range of EU-derived employment rights that the TUC worked with our comrades across Europe to win over many, many years, being scrapped at the end of 2023. Some fundamental rights that could include are rights to paid holiday, rights to paid breaks at work, rights for part-time workers against dismissal and parity treatment, rights for workers whose employer is bought out by another company, so-called 2P rights, parental leave rights, and agency worker rights. But there are many, many others as well. We know these rights particularly benefit women and other marginalised groups and those on temporary contracts, so it would be really devastating if those rights were lost. Then there's our concern about the bill removing the direct effect of EU law by wiping the slate clean of interpretation and case law that our courts have built up over 50 years. It means settled interpretation of EU law will need to be relitigated, which means for a worker to claim rights, they will need to undertake costly litigation in an employment tribunal. And it's a system, the employment tribunal system, that's already very, very slow because it's massively under-resourced, as we've expressed a lot of concern about. We know for many workers, particularly low-paid workers, they will not have the time or the resources to be able to go through that legal system to claim those rights. So it'll mean, in effect, people are priced out of the justice system. And then just finally on the EU-UK agreement, as I say, we are concerned that the bill, by removing fundamental rights, will mean that the UK is are going against its commitments on level playing field, which are commitments that the UK must maintain right to the same level they were at in December 2020 when the UK-EU Trade and Cooperation Agreement was signed. That would mean the EU would be able to levy tariffs on UK goods, which would obviously have a huge impact on UK exports in the EU, and would therefore impact on the workers employed by those businesses, and again have wider impacts on the economy and communities. We are very clear that those level playing field rights are fundamental. They must be maintained. The UK government should extend protections of workers' rights post-Brexit, not be removing them. So for all these reasons, we're calling for the bill to be scrapped.
Thank you very much, Rosa. Simon.
Well, Rosa's given an excellent outline of the breadth. So I've looked at the number of rules that will be affected. We think there are 160 regulations in the dashboard that mention the word safety. And there are 58 regulations under the category of health and safety. So these are, a lot of it is the rules that protect workers from their employers not looking after their safety. But it's really important to understand this is not just random red tape looking after workers. Most of the rules have knock-on effect on members of the public. So if you have rules about working at height and lifting things with cranes and scaffolds, of course the workers are impacted, but so are the pedestrians in the street. It's their safety that matters too. Or the rules about asbestos in buildings. Yes, it affects the workers doing the work on the building, but it also affects the children if the building is a school. So it's very important to understand the breadth of this. So health and safety, all those rules would go, all those specific rules would go. Rules to require you to do a risk assessment would go, the rules of safety on construction sites, the rules of safety for major accident hazard sites. Think of the Buncefield explosion. All those rules of safely storing your fuel, that all disappears. Fire safety, the fire safety rules, all the specific rules would go. Product safety, think of all the requirements to do a product recall in certain circumstances would go. Toy safety, think about whether you want your children to be sucking on a toy and a bit breaks off and they choke on it. Well, there are a lot of rules about that. That could all go. Electromagnetic compatibility, I'm just giving some examples. You want, when you buy your mobile phone, you don't want it to interfere with the emergency systems on your car that help you to brake safely. Well, those protections are all in these tedious red tape rules, but they've all been created for a reason. Food safety, food hygiene, food labeling. The idea that this is all just stuff imposed upon us from Europe. Do you remember there was Natasha's law recently, which was to do with food allergies from sandwiches bought in a sandwich shop and whether the food allergens needed to be labeled. So the UK made specific regulations to deal with that, but the regulations were made under the auspices of the EU law. So that rule could be scrapped. So I just want to express the breadth here.
Yeah. The list goes on, doesn't it? And then we'll cover more of this later in the session. But William, would you like to add your introductory remarks?
Thank you, Chair. The answer to the question is the bill has profound consequences across all sectors of commercial activity. Everything from product regulations, environmental regulations, health and safety at work, employment rights. So we feel that the period of the sunset clause, which is being proposed in the bill, is really insufficient to deal with both the breadth of regulation covered and the depth of areas that it also covers too. And of course, during this process, we've discovered that the dashboard is not a comprehensive list. And in fact, there is no requirement in the bill as currently drafted to produce a comprehensive catalogue of retained EU law. So in that sense, we don't even have clarity about the precise full list of legislation we could be dealing with. We've discussed this very closely internally amongst our chambers. We've surveyed members about this. Our conclusion is that the best outcome is to really delay the effect of the sunset clause until the end of 2026. We also are of the view that there are consequences around the operation of the intra-UK internal market as well, because of course employment legislation is devolved in Northern Ireland, but not in the rest of the UK. There is essentially, given that everything is to be sunsetted, a requirement to re-regulate in those areas where the devolved administrations would want to put rules in place. And so we do run the risk of having, potentially different rules and different approaches in place in Scotland and in Wales in particular, relative to that at Westminster, compared with what we have at the moment. So for that reason as well, I think the requirement for business and other stakeholders to be consulted on all changes, which is not there in the bill at the moment, and the need for reports from the Office for the UK internal market and from government in terms of what the consequences are, proper impact assessments on any proposed changes. We think that having additional safeguards within the bill, as well as the delay to the sunset clause period, would be justified amendments.
Thank you very much, William. I'm now going to hand over to Tamara.
Thank you, Chair. So my question is, do you have any sense of which retained EU laws the government is likely to keep and which EU laws are likely to be left to expire? William, it's lovely to see you again. I'd like to start with you, please.
Thank you, Tamara. The public position is no, we don't have any indications. My understanding is that DEFRA have been consulting some stakeholders in the food space in terms of what changes they might want to see and what regulations they might want to keep. But we haven't had any specific engagement with BEIS or with DCMS or other departments about what proposals that they have. We've had informal assurances that on major changes they would seek to consult, but there's nothing on the face of the bill. And our sense is that in order to ensure we don't face unintended consequences whenever the sunset clause comes into operation, stakeholders should be consulted on each and every proposal, whether it's simply an issue of a regulation being allowed to expire, whether it's an area where the government is proposing to change regulation, or whether they're proposing to use the powers within the bill to put it into this category to preserve it until the end of May 2026. So I think for those reasons, and also the effects that this has on the legal system. I mean, we've been used to having very important retained EU law interpreted in the context of general principles of EU law. It's been subject, of course, to primacy as well. Removing these characteristics is a huge change to the way that rights are operated by both employers and by employees. And so, again, we need to proper consideration of this. We need to proper training for both employment specialists, for judges, for tribunal chairs. The legal profession itself will have to be trained on what the consequences of this all mean. And so, again, for this reason, we think that a December 2023 timeline is simply unrealistic.
Thank you, William. I mean, I think there's been a diminishing return on consultation for the last couple of years, which is possibly another question. But Rosa, I wonder whether you've got some thoughts to add before I go to Simon.
Yeah, thanks, Tamara. So similar to William, we've had no word from the government about which EU laws are likely to be kept and which will expire. And therefore, we have to assume that all EU-derived rights and secondary legislation on employment rights are at risk. And that's a whole range of rights, as I've already highlighted. There's been no consultation to date about the possible impact of removing those EU laws either. And as William says, nothing in the bill to require that consultation either. So that all rings huge alarm bells for us. We would call for that consultation from the government, and the government to demonstrate how they, as they once said they would, protect and extend employment rights post-Brexit, because the whole direction of travel with this bill is about tearing up rights which nobody voted for. So we would really call for that urgent consultation, as well as for this bill to just be dropped, because that is not going in the direction about extending rights. Just to highlight that in the EU, new rights are being implemented for workers around platform work, around digital rights, around minimum wages and collective bargaining. We're already falling behind employment rights in the EU. Why isn't the UK legislating to keep up with the EU? We're going in the wrong direction, which is bad for business as well, obviously, because it makes us compete on an uneven playing field. So it is a really worrying direction. And as you say, reflects lack of consultation as well. I cover international trade policy, and there's also been no consultation on any of the trade negotiations with trade unions today either, which is why we're also getting the kind of trade deals that are negatively impacting workers too.
Thank you, Rosa. Simon, I wonder if you have any thoughts to add.
Yes, well, I have no idea at all whether the government have any intention of watering down provisions that protect safety. No idea. But what we ought to get is some kind of reassurance, if possible, and if possible, given in the House of Commons, some kind of reassurance that all of the regulations that have an impact on safety are going to be saved, and that this process is not going to create any diminution of safety protections. Or if not, if that can't be given, then we should be told early what safety provisions do the government object to transferring over and keeping, so that we can have a proper consultation and debate before anything happens by accident. I've been speaking to the top level at ROSPA, the Royal Society for Prevention of Accidents. They're deeply concerned about this, and they certainly want some kind of reassurance.
Thank you. Thank you very much for your answers. I hand back to the chair.
Thank you very much, Tamara. Caroline.
Thank you very much, Peter. So I wanted to come back to the issue of the sunset clause, which I know William has already touched on, but I wanted to come to Simon first, if I might, and just ask whether you think strategically is the best thing to do, notwithstanding what you've just said about exempting safety regulations, but more generally, would it be about focusing around that later date, the 2026? How much difference would that make? Or is it better to be not even talking about sunsetting anything? Just looking at it from the point of view of DEFRA, I know that they've already failed to produce the environmental targets that was required under the Environment Act. They don't have the capacity even to do that. The idea that they're going to have the capacity to do at least 570 pieces of legislation, I think they've got about 3 staff working on it when I last checked, even by 2026 might be a bit of an ambitious goal. So I wonder what your thoughts are about that sunset clause.
Well, yeah, I share your ambivalence about it. And I mean, the idea that this is all going to be done properly in time for the end of next year is fanciful. But even if you added a few years, it's still a slightly, a very large piece of work to do properly. But then there are just the political considerations, which work on both sides. If it's kicked off into the long grass by 2 years after the election, then will it ever happen? Well, that works both ways, doesn't it? That's also why they probably won't want to do it. Or it's also why, if they want to save face and find a fudge, that might be the thing. So I don't think if you're opposed to these changes, I don't think you should give up on trying to get an extended period, because that may just be the route through of least resistance and least embarrassment for the government. But don't kid yourself that it's going to be any more sensible.
Thank you. That was very clear. Rosa, can I come to you?
Yeah, I mean, for us, this doesn't alleviate our concerns, the proposal to extend the sunset clause, because we still wouldn't have certainty that we would have all the fundamental rights derived from EU law protected, retained, and it would still mean the primacy of EU law is removed, which would still create all those legal uncertainties and additional costs and delays for workers to be able to claim their rights. So it really just pushes it down the road only a very short amount as well. And on the workload issue, I mean, it's a workers' rights issue, and we echo all the concerns have been raised by our civil service unions about the impossibility of this task, even within the 2026 timeframe as well, which means it's highly likely that even if a version of EU law was retained in UK law, it's highly likely to not be up to standard, and Parliament would not have proper time to scrutinise it. So for us, extending the sunset is not a way to alleviate the concerns, only getting rid of the bill would.
Okay, that's helpful, thank you. And William, did you want to add anything more on the issue of the sunset?
Yes, I mean, I think it's, as well as a capacity issue within government and, you know, within Parliament and for stakeholders as well, and also for the devolved legislatures and administrations as well, we must also think about their role in this. There is also a question of priorities. You know, we are representing small businesses who are immensely concerned about what's going to happen to their energy bills when we get to April. You know, we have many small businesses for whom it already feels like they're in recession right now. And we think the priority of officials and civil servants in BEIS and in other departments should be getting businesses through this. You know, getting us out of recession as quickly as possible. And if they're diverted from that task by having to do this in an over hasty way, then we think that doesn't serve the country well at all either.
That's really helpful. Thank you so much, all of you. And I'll hand back to our chair. Who is on mute.
I'm on mute. Sorry about that. Thank you, Ashkan. Paul, can I turn to you, please?
Yeah, thanks, Peter. And I'm serving on the Bill Committee at the moment and have been going through the extraordinary bulk of evidence that we've received, which is almost all of one voice reflecting the comments that many of you have made so far this morning. But I just wondered if I could ask whether there is any business or sectoral case for explicitly revoking EU law. I mean, is this legislation that any sector or any business was actually looking for government to do? Perhaps I could start with you, William, and it's good to see you again.
Thanks, Paul. Well, we didn't ask for this legislation to be brought forward. You know, we've had a range of asks about, you know, what's needed to fix the trade and cooperation agreement, but certainly this wasn't amongst any of them. I mean, I think it's important to remember there are powers within the European Union Withdrawal Act 2018 as amended already to make changes, you know, to retained EU law. You know, clearly, you know, what the government is looking for is additional statutory powers to fast track any repeal or amendment of direct retained EU law, which currently has the status of primary legislation in EUWA 2018. So, you know, that's an issue for government. It's an issue for you as legislators, but it's not something that business was asking for. I mean, you know, what we were asking for is actually more help for companies trying to export their food products to the European Union, more help on issues like VAT, more help on mutual recognition of professional qualifications. Those are our priorities in terms of fixing the TCA. And this kind of theological approach to some of the issues around the status of EU law was not something that we requested or we view as particularly necessary at all.
Thanks very much. Simon.
Well, I'm a solicitor representing the regulated companies, and I can tell you that in my experience, none of them have been complaining about the laws. They might complain about the way the laws are enforced, and they might complain about the way they're enforced on their particular incident, but they don't ever say that the law itself is too onerous, tying them up in red tape. They know they have to comply with these things. There's certainty, and the laws seem to work. Do you recall, some of you will recall from the Labour government, Tony Blair initiated something called a red tape challenge. And on the field of health and safety, he got Professor Lofsted to do a thorough review of all health and safety laws with the idea of identifying any unnecessary red tape on safety, simplifying it and removing it. And the thorough review was done, and almost nothing was found to be over the top or OTOs in those laws. There were one or two tiny tweaks. But the point is, that was the way around it, which is to look at where is the law broken. If you identify any broken laws that are too onerous, let's change them. But this has turned everything on its head. Let's throw it all away unless it can be justified. So we don't know, but I'd be very interested to know, is there any specific regulation in the safety field that the government do wish to water down? Start with that question. If the answer is yes, let's discuss it. If the answer is no, just give a reassurance that that is not what this is about.
Well, thanks, Simon. And within the Bill Committee, we've been putting exactly that challenge without success to the Minister. Rosa, your perspective.
Thanks, Paul. Thanks for all your work highlighting our concerns in the Bill Committee. So as I highlighted earlier, we've written a joint letter with businesses to Grantshops as well as other civil society groups saying removing this legislation is going to create a huge amount of legal uncertainty, which is going to be very costly to business. And so that is echoing exactly as William has said as well. It's not something that businesses we are speaking to are calling for. Also, the fact that, as I say, if it breaches the EU-UK Trade and Cooperation Agreement, there could be tariffs on UK businesses' goods in the EU, which nobody wants. We're working with businesses both in the UK, but also across the EU in the civil society monitoring body for the Trade and Cooperation Agreement called the Domestic Advisory Group. And last month, we released a joint statement with businesses across EU and UK, which was highlighting the importance of those level playing field commitments to make sure there's fair competition between the UK and EU. So as I say, this bill is just driving us not in a direction that we are hearing employers want to go to. There should be instead that consultation with trade unions as well as business about how post-Brexit we can improve rights and keep up at least with the EU standards, but let's go beyond them, not go in the opposite direction. As others said, this is an ideological project that business as well as unions have certainly never indicated that they have wanted.
Thanks very much to all three of you. I'll hand back to now.
Thank you very much, Paul. Philippa.
Thanks very much, Peter. I mean, part of the issue seems to be this enormous sunsetting of what is now approaching almost 4,000 regulations, and it'll suddenly take us out of alignment with the EU. But we also know that the National Archives found 1,400 that the government hadn't even factored in. So if I can ask you what you think the effect will be in obviously from your point of view, and how much are you concerned about other things the National Archives hasn't found and therefore maybe automatically sunsetted at the end of next year without anyone even realizing. I'm a medic myself, Simon, so the health and safety aspect, which I saw through my career as a surgeon, the kind of workers' injuries change is something that I have great interest in. So if I could start with you and then I'll come to Rosa and William.
Well, I share your concern. There's a huge opportunity for things to slip down the back of the sofa and not be noticed. Massive. The opportunity for muddle, but also I'd add one more, which is there are a lot of cross references that you're not really necessarily aware of. You look at one set of regulations and they use a term. And in order to understand that term, you actually need to look at one or more other regulations. And they could muddle things up by removing one without the other, and you don't know where you are. It's a lattice that's been very carefully created, the laws that are there, and you start picking at it without knowing what you're doing, and you just create confusion. Not to mention, as Rosa mentioned earlier, the way that the case law that backs this up suddenly disappears, and then you also lose a whole lot of learning on how to sensibly interpret things. So yes, muddle is likely to be the consequence, without any doubt, of this approach to lawmaking.
So do you think the government should have been bringing, I'm sure most of us do, should have been bringing what they want to change with a rationale for why they wanted to change it, rather than this somewhat kind of shotgun approach?
Well, to any rational observation from a lawyer, yes, that's clearly the case. But then their approach is based upon ideology rather than, as far as I can tell, any specific law they want to change. Because if there was a specific law they wanted to change, they'd be talking about it and changing it.
Thanks very much, Simon. Rosa, if I can come to you. So the overall effect, but obviously this fear about kind of unknown ramifications from law just dropping.
Yeah, we're very concerned that we don't even have the full picture, as you say, about the range of laws that will be reviewed and potentially scrapped. And so that for us brings huge concerns that it will mean that whole range of employment rights that derive from EU law could be scrapped. Or if it's not scrapped, because as Simon said, it's such an intricate process, if it's re-legislated for, it will not be in an adequate form. And we know that Parliament has a very, very tight deadline at the moment, just up to the end of 2023, to pass any new UK versions of EU law. And so Parliament will be under huge pressure to pass even very inadequate legislation that does not provide proper protection, just to have some kind of protection. It's kind of analogous to the awful no deal versus bad deal situation that the government put parliamentarians under at the end of 2020 with the EU-UK agreement. So we are really concerned there's a high likelihood that we are not going to get all the laws, anywhere near all the laws, re-legislated for. And then there's the whole issue about removing direct effect, which will create the legal chaos no matter what. So yeah, as I say, civil service unions have said, and we know that they've expressed these concerns long in advance of the government proposing this legislation, that this was an impossible task and a task that was likely to leave huge holes in protection, to mean that all those fundamental rights around paid holidays, sick pay, etc., are at risk. So we're really concerned about the whole approach. The fact we don't even have a picture about what's at risk fully means everything could be potentially.
I mean, we've already heard the narrative from some government benches about workers' kind of right for annual leave or public holidays. And, you know, as a doctor, I know that the 48-hour working time directive has been in the sights for many years. But as a junior doctor who worked 132 hours in a heavy week and 75 hours in a light week, I would not like to see people returning to that kind of working, which isn't safe no matter what industry you're in. So I think you're right to be concerned. And if I can come to yourself, William, so the same aspects, the impact of the sudden change of alignment with EU, and obviously for yourself, particularly exporters, but this danger of the unknown.
Indeed, Philippa. And I think the removal of primacy and direct effect will increase uncertainty as to what the law is. That's going to mean more litigation. It will mean more costs for business in terms of, you know, things like insuring against litigation. So there will be extra compliance costs, I think, really derived from those two measures alone. I think the key concern is that, if this process was to be used to sort of diverge from legislation on traded goods, that simply would impose costs on firms manufacturing in the UK who want to export their products into the European Union. So again, if there are any proposals anywhere in government to do that, we would dissuade them from bringing them forward and ask them to drop them. The last thing we need with the economy the way it is to increase costs for manufacturers and exporters. So falling out of alignment would simply impose extra non-tariff barriers on our goods being able to be sold in our largest market, which is the European Union. The other concern is, if there is anything that's proposed which would affect the operation of the non-regression clause within the level playing field, then of course the European Union could impose measures and take the UK through the dispute resolution processes, and then potentially we face tariffs on our goods some way down the line.
I mean, they describe this as removing red tape, but for anyone who's exporting, is it not that actually doing this could increase the red tape they have when they're trying to export?
If this process was used to diverge from long-standing regulations on electrical and industrial products, food products, other goods and services, and we get different regulations on this emerging from this process, then yes, that would impose extra costs on businesses, particularly exporters.
Thank you very much to all three of you. Back to the chair.
Thank you, Philippa. And Claire, I think let's move to you and delve a little bit more into the detail of unintended consequences here.
I think Philippa has and will cover most of those. Thank you.
Okay, well, let's go on. Paul, you had another question.
Well, I did, and unusually, we're ahead of time, and I think that reflects the extraordinary consensus that there is on the issues that we are trying to explore. And as I said earlier, I mean, that's certainly been reflected in the evidence that we've had to the Bill Committee. I've been on a number of Bill Committees, and there rarely has been such agreement from such a broad range of organisations about the folly of this enterprise. But I wonder if you could just perhaps in bringing this part of the session together, and I recognise we've kind of covered some of this, but just reflect on what the main implications are for your sector, and what your main recommendation would be to the government on this bill. And perhaps I can start with Simon.
Thank you. Yeah, well, I think I want to just paint a picture for what this world will be like without these regulations. Have any of you seen those pictures of what they do with scrapping of ships, where they take them to the least regulated regime in Asia, and they ram some dying ship up onto the beach, and then a whole lot of people with no safety protection or provision go crawling over the ship, pulling out bits of metal with no safety harnesses, and dealing with dangerous hazardous chemicals, and they pull it all apart to get the scrap value. Well, are we heading to a world where those ships don't need to go off to Asia anymore? They can just come up the Thames and beach themselves in the Thames estuary, and we can all pull it apart without any concept of safety. Is that what we want? That's, it's the sort of Singapore on Thames idea. So what we're looking at is potentially crazy if they really mean it. The uncertainty and the cost have been discussed. The bill should, in my view, be dropped. But if not, if they do want to keep it, then they really must be pushed to give a reassurance as soon as possible. Stop the delay, reassure we don't want to water down anything on safety, a binding reassurance. And then many of us who are agitated can at least relax to a degree, and be pushed to say what they do want. They've got to reverse their viewpoint. What do they want to remove, so that the rest of it can just be saved? And but the reality is, the bill should be dropped.
Thank you,
But
Simon.
I think we have to focus on the art of the possible here, because it's not going to be.
It's not going to be dropped. I mean, I think it's a fascinating position of a sort of legacy bill trapped between the divisions in the governing party. But the minister is struggling, I think, at the moment to defend it in our proceedings. But we have been pressing on precisely those issues, Simon. But could I ask you, Rosa?
Yeah, I mean, just to focus on what this would practically mean for workers, it could mean them losing paid holiday, losing them having the right to have rest breaks at work, having to work those incredibly long hours we've already heard about, losing parental leave rights, losing rights as agency workers to equal treatment. This is going to affect workers who are already marginalised and mean that they are more exploited. So just day to day, it will make life so much worse and mean hard-pressed workers feel even more like they are receiving terrible conditions at work. It will mean, as I say, if they want to claim rights, they could be in a justice system that's completely gummed up by legal chaos and delays, and mean that they don't have the resources to even claim those rights as well, which could mean, again, that they just have to suffer exploitative treatment at work, which is completely unacceptable. It's a race to the bottom scenario where only bad employers benefit. As I say, or the good employers that we're working with, the vast range of employers that we've heard from, do not want this either. So the kind of vision that the government is presenting by this is a situation where workers and businesses are put in a really terrible situation of worsening rights. And as I say, and then with the EU, we are potentially breaching an international treaty, potentially having tariffs on our goods, which will again negatively impact on business and workers here. So what we need is for this bill to be dropped, and engagement with unions and business, as I say, about that post-Brexit future where workers' rights are protected and enhanced, and we have the highest standards in the world. That should be what we are aiming for. That was the original vision that we were presented post-Brexit by the government, but this is going completely opposite direction. So we are calling for it to be halted. I think it's really important, as I say this morning, that we've got a really strong coalition calling for the bill to be dropped for that whole range of reasons I've highlighted. So we have confidence that momentum is going to build because of the chaos, uncertainty, and damage that it's going to create. So we are going to continue to push on that, and I think it's really important that message does grow louder too.
Thanks very much, Rosa. And finally, to provide the voice of business, William, the main implications and your recommendation to government.
Thanks, Paul. I mean, the main implications will be uncertainty as to what the law is, what the rules are, what should apply in a workplace, what would be the rules in terms of traded goods, what will be the environmental rules to be followed. Will there be differences in regulatory approach between what happens at Westminster and what happens in Wales and Scotland? Will those introduce increased costs for businesses? So a whole panoply of concerns. And if this bill is pursued on the current timescale without having rights of consultation for business and other stakeholders written into the face of the bill, and clear metrics for government written into the face of the bill in terms of providing an accurate list of exactly what regulations, directives, decisions, and other EU secondary and tertiary legislation is involved here, then we are going to, I think, have business divert its efforts from what it is best at and what it wants to do, which is to get through these difficult economic times. And we'd have to divert resources within companies, which they can ill afford, to having to comply with new rules being introduced without sufficient consultation and being done on far too quick a timescale.
Thanks very much indeed. I just share with you that we pressed an amendment in the committee on Tuesday asking the government to produce a list, simply to produce a list of all the legislation that this would cover. The minister's response was that the government couldn't, the civil service couldn't do that because it would be too burdensome to produce a list. Where that leaves us in terms of their capacity to review and replace all of these laws is the question that's still hanging. But thank you very much for your
Thank you very much, Paul. I think it's very unusual for us to complete the slated questions for our session so quickly, but I think that reflects the unanimity really about on all these issues from all our witnesses and questions, and it does paint the most disturbing picture of this process and its implications for us. Particularly following up on Paul's last remark, because there seems to be an absolute lack of capacity in the civil service to deal with what's proposed. Is that a fair criticism to level, do we think, or is it part of a obfuscation of what's really going on here? Do any of you, the witnesses, have a view on that? Simon?
Yes. I mean, it's fundamental. The task is monumental for the civil servants, and it is beautifully demonstrated. If they can't make a list of what's impacted, how on earth are they going to think about it, let alone think about it intelligently and allow the opportunity for consultation and debate?
Yeah.
And I just again highlight that the civil service unions have made it clear they haven't given the staff or resources. They've obviously faced years of cuts. Now they are in dispute around pay. They have not been given the resources needed for this task. So yeah, it is an impossibility. The government knows it's an impossibility, and it will mean that rights will be lost as a result of it.
And one aspect we haven't discussed, but I know is of relevance to the Commission, is, and it's sort of under the table, and it's not stated as one of the aims of the bill, but in my view, it seems to be the obvious aim of the bill, is this bill is a piece of wrecking legislation to make it harder to rejoin the single market in due course. I mean, it's not stated, and this it's one of these things in Parliament at the moment where the battleground where Labour can't talk about Brexit, the Conservatives can't talk about Brexit. It's again, what is this all about? This is, what's the purpose behind this? It must be, in my opinion, a wrecking purpose, not any real purpose other than that.
Okay, William, do you have anything to add?
Well, I mean, clearly, in terms of the processes for changing retained EU law, these are a matter for, in terms of what goes on in Parliament, these are matters for legislators and for government and the other political parties. Our priority is that if changes are being made, whether that is allowing things to expire without any regulation being put in place of them, or to make significant or any amendments to the current EU retained statute book, then stakeholders should be fully consulted. That's our priority. And that, I think, is the best way by which any government can make good law, is to find out how it's going to operate in the real world. And that means coming to business, it means coming to Labour, it means coming to NGOs and other stakeholders to find out what the real world consequences would be, including the unintended consequences of changing or allowing to expire any of these regulations.
Yes, well, I have to say, William, what you say makes absolute sense. But as Tamara said earlier, there is a pattern of diminishing returns to consultation under the current government, but it must be a central recommendation, I think, for the Commission to make, that the consultation has to happen before irrevocable steps are taken here. Is there any, Commissioners, is there any other question following this discussion that you'd like to raise before this section of the session closes?
Hilary has a question, Peter.
Oh, sorry. Hilary, please.
Thank you very much. Indeed. Now, I may be an irredeemable optimist, but given what I've been listening to and the wonderful evidence we've just received, I find it very hard to think that since the government can't explain why they want to do this, in other words, what are the EU laws and regulations, directives that they find particularly objectionable, I find it quite hard to believe that in practice, they're just going to sit on their hands and say, this is all going to die. If one takes the example of the row that this created, obviously with the trade union movement, as we've just heard in what Rosa has said, but the green groups united together in saying, there's a threat to the Water Framework Directive and the Habitats Directive and so on. I said in my speech in the House of Commons, I suspect that by the time we get to the deadline, ministers will have said, well, we'll just hang on to these things for the time being, because the argument has been put overwhelmingly strongly that there's no way you could do a proper review of them anyway. And that my conclusion is that this is for show rather than real, because the consequences of losing all of this law would be so enormous and profound and destabilizing. I find it hard to believe that that is actually the plan. Now, I'd be interested to know what our witnesses think, and you may tell me you are an irredeemable optimist, Hilary, and you need to wake up. But I find it difficult to see that they're going to do this. Would anyone like to comment?
Well, one of the difficulties, you're being optimistic, that's great, but one of the difficulties is that even if they try and name specific regulations that they do want to carry over for the extra 2 years or whatever it is, and therefore kick it into longer grass, there's a concern that things that are unnamed and pieces of EU law that are by direct effect will disappear anyway because of the breadth of what they haven't got the scope of it.
Right, that's a very good point. And their inability, as Paul just told us, to provide a complete list of all of the things that are affected by this legislation does make the point that stuff may got lost by accident because they didn't have a record to check it against. So that is probably the biggest risk of all. Yeah. Anybody else? Rosa?
I'd just highlight that because Parliament is going to have so little time to scrutinise the raft of legislation, even if the government says this is a comprehensive list, there's going to be so little time that it's highly likely it will not be comprehensive. As Simon says, things will fall away. And there is also a kind of deregulatory ratchet that things cannot be more burdensome or regulate more than is already in the statute book. So we know that there is a whole emphasis on deregulation of the kind of reformed version of law that will come forward through this process. So I think it's highly likely it will not be adequate. And the fact that we've removed direct effect will have the separate impact of creating the legal chaos, which you can't get around, even if there's the most comprehensive re-legislation process.
Thanks. Willie?
I would imagine, Hilary, that a government that's and Parliament as a whole, grappling with these enormous issues about the future of energy supply and cost of energy, what's happening to economic growth? Are we going to be seeing increasing unemployment over the next year or so? Problems of huge magnitude and huge importance to all of the stakeholders who've given evidence this morning, that perhaps a little dose of pragmatism by putting this on the back burner and at the very least delaying the implementation of the sunset clause would be the action of a wise government, which was genuinely putting people's priorities first. So I share the tinge of optimism that as this bill goes through further parliamentary stages in the Commons and the Lords, I think there's going to be an emerging cross-party consensus that there are other priorities for now, and that this should be given sufficient time that it doesn't damage business at a time when we're really concerned about the consequences of recession.
Thanks very much. I think the technical term we're all struggling for is this is a bonkers bill. That just about sums it up from my point of view. But thank you very much for letting me come in, Peter.
Not at all, Hilary. And Stuart, you've got your hand up.
Thanks, Chair, and thanks to the witnesses. It's been a really, really helpful session this morning. Just picking up on something actually, William and I discussed just yesterday. Actually, I think I have some concerns just around the impact, obviously, that it'll have on the protocol divergence. The divergence issue will just become much more acute if it's not dealt with within the next year. But one of the questions I have was just. One of the concerns I have, is just around the time frame and the coincidence of it with the suggested or at least proposed time frame around the implementation of the border operating model and the impact that potentially will have, because you have both the suggested introduction of SPS controls from 31st December in GB together with this bill. And where we are right now, it's quite a frightening prospect as to where that will take us. But my question is more in relation to the rollover trade deals, William. What impact, if any, will this bill have on those 71 odd trade deals that were rolled over from the EU? Just keen to hear if there is anything there that is of note or of interest.
Well, indeed. I mean, those trade deals where there are references to standards which are underpinned by EU law, yes, there could be unintended consequences from that, of course. I mean, there are, negotiations going to be coming up in terms of South Korea, where there are key issues in play for UK manufacturers on the rules of origin and whether EU content can continue to form part of UK goods that would get preferential tariff treatment in South Korea. So yes, there are all of these issues that we have that will need to be resolved in the next couple of years in terms of some of these continuity trade agreements, for which moving too quickly on this issue of retained EU law could cause again, unintended consequences in terms of the deal that we end up with.
Rosa, do you want to add something?
If I could just come in briefly, I think this bill also indicates the UK is not a trustworthy partner when it comes to international treaties, because it, as I say, is potentially going to breach the UK-EU treaty, which is the most important one the UK has signed. So the UK trying to now get new agreements with the likes of Canada and Mexico and Pacific countries, I think it really indicates that it's not a partner that many countries would want, because it's not fulfilling its international obligations. And just if I could also, because you mentioned Northern Ireland, just highlight concerns that Northern Irish Council of the ICTU Union Centre have highlighted, that this bill, by potentially removing fundamental workers' rights in Northern Ireland as well, does stand to go against Article 2 of the Northern Ireland Protocol, which talks about non-diminution of rights. And so they are very concerned about the implications of that for workers in Northern Ireland in relation to those in the Republic, which is another, the UK government has not indicated how it would be fulfilling that article as well. So I think that's a really important concern to highlight. Thanks.
Thank you very much, Rosa. And that's actually a very good segue to our second session here. So let's draw the first, where we've talked about implications for business, to a close. And And I'd like to thank Rosa, you and Simon and William very, very much indeed for your contribution. Please do stay if you have time. But now let's turn to our questions about the constitutional implications of what's proposed. And could I start by asking our witnesses to introduce themselves briefly? George, perhaps I could start with you.
Yes, hello everybody. I'm George Perrett, KC, I'm getting used to saying that now. And I'm a barrister at Monkton Chambers. I used to specialise in EU law and now specialise in the smoking debris that is left of it in the UK and other things. I also ought to say that I am a member of the Society of Labour Lawyers, indeed on the executive of that body. So I better put that on the table as well.
Oh, thank you, George. Neil,
right.
Is Neil on?
Good morning. Yes, thank you. So I'm Neil Warwick. The day job is EU lawyer with DAC Beechcroft, an international law firm, specialising predominantly in competition law, state aid, subsidy control, structural funds. I'm also a member of the FSB through a not-for-profit business that I co-own. From 2016 to 2020, I was the UK policy chair for Brexit. I'm now the UK policy chair for international trade and regulation. And the FSB represents 140,000 small and medium-sized businesses.
Thank you very much, Neil. And finally, Jill.
Hi, I'm Jill Rutter. I'm a Senior Research Fellow at UK and Changing Europe, based at King's College London. I'm also a Senior Fellow at the Institute for Government, where I used to run the Brexit programme, and I'm a former Senior Civil Servant.
Thank you, Jill. Tamara.
Thank you, Chair. So the first question I'm going to ask our evidence givers is, what is your overall view of the bill and its implications? Jill, could I start with you, please?
Okay, thanks very much, Tamara. Well, I can sort of understand the motivation for the bill. The bill clearly came out of frustration, first from Lord Frost and then from, as far as we see from Jacob Rees-Mogg, that government departments were not giving what they would say, realising the benefits of Brexit sufficient attention. So I think the rationale for the bill was, if you like, and this may relate to Hillary's experience, DEFRA, was from a department whose agenda is not being taken very seriously across Whitehall. It's a bit of a sort of plea to put rocket boosters under their efforts by saying, actually, you all have to do this, and we're going to give you a deadline. Remember, the initial deadline was 2026. That came forward when Liz Truss became Prime Minister to this 2023 deadline after the sort of slight competition we had during the Senate for Leadership. So it's an attempt by the business department, as now is formerly the Brexit Opportunities Unit in the Cabinet Office under Jacob Rees-Mogg and Lord Frost, to get other departments taking their agenda serious. In a sense, it follows on from attempts we've seen by other governments to deregulate or regulate better by establishing machinery, mechanisms, having repeated red tape challenges, because there's always a sense at the centre of government that, and it's a bit like being the Treasury, where you sort of think we've got to look after the money and we've got to raise the taxes, and every other department is very spendthrift. There's a bit of a view always from the centre that there's one person in government who's interested in, reducing the burden of regulation, trying to regulate better, and every other department's in a bit of a conspiracy against you to hang on to every bit of regulation they've got and to pile on regulation to achieve their objectives. And one of the very interesting ways I think that we always fall into thinking about regulation in the UK is that we always see regulation as a cost. So we're always talking about regulatory costs. And we fail to realise that actually you shouldn't be introducing any regulation where the benefits don't outweigh the costs. If you do, you should be getting rid of it. That is just bad regulation and pointless thing to do. So there should always be a net benefit somewhere around from the costs you're doing. But I think this is a bit of a cri de coeur from the Brexit Opportunities Unit, is why we ended up with this legislation.
Thank you, Jill. George, could I come to you, please?
Yeah, I think it's helpful just to take a quick step back and remind ourselves, why retained EU law exists as a category. It exists as a category because in large parts of our law, ranging from really sort of very technical stuff like aircraft safety regulation, which is a classic example of Jill's point that that regulation doesn't always need to cost. One rather needs aircraft safety regulation, and nobody would ever get on an aircraft if it didn't exist. So the EU law covering very technical areas, aircraft safety regulation, a lot of employment, environmental law, habitats directive, habitats regulations, 2P regulations, working time regulations, were EU law, came from EU law. And in a lot of those areas, there just wasn't any UK law at all, effectively. Aircraft safety is one of those. When we left the EU, you therefore needed to preserve all these areas of law in order to avoid a sudden sort of dramatic void in the legal system. And there simply wasn't time to go through it all and think about whether it should be changed. In fact, what actually happened was the law was gone through with a view just to making sure that it worked. So not actually changing it, but just making technical amendments to tidy it up and remove references to the Commission and replace them with UK regulators, etc. And that process itself took an enormous amount of government lawyer and official time over the years leading up to Brexit. The retained EU law was kept. In order to keep it, you had to do some rather strange things from a UK perspective. And essentially what those strange things boiled down to was making sure that these texts that were texts largely originating from the EU, or alternatively, they were UK texts that assumed an EU law background, such as UK regulations implementing EU obligations. In order to maintain the continuity of the law, you had to make sure that all these texts were interpreted in the same way as they would have been had we remained a member state of the European Union. So you had to do various things. You had to ensure that the courts remained bound by, subject to some exceptions, judgments of the European Court of Justice interpreting those texts. You had to make sure that basic principles of EU law that apply when you interpret these texts continued to apply. You also, and this has got a lot of people very hot under the collar because they don't really understand what it means, you had to preserve what was called the supremacy of EU law. You can see why people get excited when they're told that you still have the supremacy of EU law in our system. But in fact, what it is simply a technical rule that maintains the existing hierarchy of different rules in our system. While we were a member of the EU, if you had an EU regulation passed in 1990 and a subsequent Act of Parliament passed in 2000, the Act of Parliament remained subject to the pre-existing EU rule. That's not normally how legislation works. Normally later legislation has priority over earlier one. But if the earlier legislation was EU legislation, it kept priority. And so that rule was hung on to largely because nobody could understand, and nobody had the time to understand, and still nobody has the time to understand precisely what the consequences would be of changing that hierarchy of rules. In order to work that out, you need to go through every single rule and work out how changing its hierarchical relationship with other rules would affect the substantive law. And unsurprisingly, civil servants, lawyers have got better things to do than that. So that's why we have it. What does this bill do? Well, I have some sympathy with some of it. Retained EU law is an odd category, and it's going to be an increasingly odd category as time passes because it freezes EU law as it stood on the 31st of December 2020. EU law is changing all the time if you look over the channel. And I can reel off a number of areas where the rules are now quite different in the EU to what they are under retained EU law in the UK, because divergence isn't all one way.
So the confusion's going to be that we're going to be stuck in ASPIC and they're going to be evolving.
They're going to be evolving.
Yeah.
And so it was always sensible to go through it and to check that it still worked, either technically or that it to review it, perhaps to follow what the EU was doing, which would require legislation and change. So there is a need to change it. It is an odd category, and it's also fair to say that over time, if we're out of the EU for 10 or 20 years, then you will no longer have the benefit of lawyers and judges who are steeped in EU law, who know how it works. That's true now, but obviously it's going to become less true in 10 years' time. So there is a need to do something about it, but that's far from saying that you need what the bill actually rather dramatically does.
Thank you, George. I'm aware of time, but Neil, if I could just come to you quickly before I go back to the chair, if that's okay on this point, and sorry around the time.
Yeah, not a problem. I mean, sort of at the risk of answering the question, the overall view of the bill from a practitioner's point of view is that it's utterly fascinating. It's the biggest change in law I've ever seen in a 30-year career. So from an academic perspective, very, very interesting. From an FSB perspective, we've got reams of evidence that say that, our members and SMEs in particular are disproportionately affected by regulatory change.
Exactly.
You look at the makeup of business in the UK, nearly 99% of businesses are SMEs, employing 60% of the workforce.
Yeah.
Now we've seen, legislative changes, 2 or 3 things that can really impact on our members, and we get the constant feedback. We don't have the bandwidth to fully understand this, implement it, keep up with it. So I guess from an FSB perspective, our worry would be if you have a wholesale change in regulation very quickly, it's just going to cause confusion for our members and make trading very difficult for them.
I'd agree with you from the fashion industry. That's what I hear too. They're already the majority SMEs, 99%, and the relationship that's shifted with their largest trading partner has already hammered them and they don't have the bandwidth to deal with all the logistics changes and the carnet changes. So I'd agree that from their perspective, this doesn't support them shifting adeptly. But I'll hand back to the chair now, and thank you to everyone who answered my question.
Thank you, Tamara. Charles, over to you.
Good morning. This bill contains certain clauses which appear to make cosmetic changes to how EU retained law is referred to in UK law after 2023. I'm told this is especially in relation to clauses 6 and 12. What do you think the government intends to achieve with this? And I wonder if I could start with you, Neil.
Yeah, I mean, my sort of take on this is it's mistake rather than conspiracy. The problem starts with the definition of retained EU law, which in this bill actually becomes laws we repeal. So you've got to have a different definition for the ones that we're going to keep. So they've come up with, assimilated law, restatement law, reproduced sunset law. I just think it's a drafting error, and they were struggling to find the right terminology, because they should never have really called the bill the Retained EU Law Bill, since it does exactly the opposite of retaining EU law.
Okay. Jill, what can you tell us about this? You're mute.
Sorry, I'm going to defer to the lawyers on that. So.
Right. Okay. George, tell us.
Yeah, I mean, there are a couple of things going on here. One is that some retained EU law is going to survive the sunset provision, because it's not going to be rewritten, restated, whatever. And that is then called assimilated law. And that is essentially a cosmetic change. It's just to change the labelling. There is also going to be the rules that are not are sort of rescued from the sunset, that are not sunsetted. There are various ways in which rules can be rescued from the sunset. One is simply by postponing the sunset, and that will remain retained EU law, although it's going to be called assimilated EU law. And effectively, not some things change. I'll come on to those, but not much. In relation to, then the ministers have power to restate EU law, which is effective. That's clause 12, and that essentially gives them the ability to rewrite it as if it was an English or UK legislative document. So you would get rid of the EU text. You have the fresh document, which is essentially freed from all its European history. You no longer look at it through the lens of EU law, the ECJ. You started afresh as a fresh text, although quite how fresh, we'll have to see. And then there's the process of clause 15, which is much more, in a sense, constitutionally dangerous, because that allows ministers not just to restate, but to rewrite in the sense of actually changing what it says. And we'll come on to that. So there's various complicated things going on here. Why? The question is, why are you doing this? Well, the relabeling retained EU law to assimilated law is it's essentially a bit of propaganda. So we brought this into our legal system. The restatement, again, you think, what's the point of all of this? If you're trying to keep the law as it is, why are you going through the process of rewriting it? I think there is an underlying dogma here that you find in some quarters of, from some sort of pro-Brexit lawyers, not all, but some, which is to take the view that EU law is inherently inferior as a regulatory technique because, and the criticisms of it vary and some extent contradict each other. Sometimes you hear it said that it's far too purposive, that there's not enough attention is paid to the word on the page, and the European Court of Justice goes off and adopts a purposive interpretation. I mean, I'd say my response to that is read some Supreme Court judgments on legislative interpretation, and you'll see that purposive approach is quite common law as well. The other criticism that's often made of EU law is precisely the reverse, that it's far too black letter, unwilling to depart from the text and unwilling to apply sort of basic common sense and principle. Those criticisms are in tensions with each other, but you tend to find the same people making the same points without quite spotting the tension between them.
Okay. Thank you. I think that's given us some insight into one of the complications. But I'll just push you on this, George. What do you think the intent here was? Was it just to find a way of moving on, or finding a way of asserting this superiority of UK law?
Well, I think Jill put the intent very well, and it's frustration that the Whitehall it seemed to be dragging its feet and going through this law, combined with a view that certain Brexiters hold. I'm sure genuinely that EU law almost inherently is less pro business, is more regulatory, less economic, it damages the economy more than common law regulation. So I have very little sympathy for that view, but that doesn't mean that those who propound it don't hold it. And if you do hold that view, then what looks to others people like a slightly sterile exercise of going through the statute book and just removing labels and rewriting it, because actually they say does have some point.
Thank you. Can I pass this back now to the chair and on to the next question?
Thank you very much, Charles. Jeff, the next question is yours.
Peter, thank you very much. Good morning. I'd like to pick something up on delegated powers, please. I wonder, does the panel feel that delegated powers in the bill are proportionate? And have there been or are there any comparable precedents, please? Neil, could we start with you, please?
Yeah, I mean, really interesting question. The short answer is yes, the delegated powers are proportionate to the task in hand, but that means you've got to recognize the task in hand is absolutely monumental. So you need very wide-ranging sort of delegated powers. you know, if the context of the question was different, is it proportionate within our constitution? I think it's got to worry anybody. You know, it's going back to the second part of your question, are there any comparables? Well, the most obvious comparables, the coronavirus bill. Now, again, I'm slightly confused. I'll probably defer to George because he'll no doubt read into it in far more detail than I. But sunset clauses predominantly are to protect unpopular legislation, so that you bring in something that you know people are going to challenge, and you put a defined date on it to review it. So, you know, lockdown is the classic example. You know, that really was, you know, a limitation on people's freedoms, very unpopular. So it had to have a, if you like, an expiry date where it needed to be checked. I'm not quite sure why you would put a sunset clause into something that's meant to be a positive piece of legislation. You know, personally, I might have considered a sunrise clause instead, where there's a cut-off date by which you have to have looked at all of the legislation and decided whether or not you're going to change it. And if you didn't, it remained as was. But again, you know, I'll defer to people with more knowledge and bigger brains than I have.
Thanks very much. George?
Yeah, I mean, I think I'd say that the delegated powers here were unprecedented, not unfortunately because very wide powers to rewrite legislation are unknown, particularly under this government. There's an increasing use of them, and Northern Ireland Protocol Bill contains some pretty astonishing, what almost might call Louis XIV powers given to ministers to rewrite the law. I think what's unprecedented about this bill is that it's the combination of the sunset clause, i.e. vast swathes of law, including law that everybody thinks it should in principle be kept, because government, every time this is pointed out, says, oh, of course, we're going to keep this, this and this. So you know, things like transfer on 2P regulations on transfer of protection of employment and businesses, transfer working time regulations, habitats regulations, every time these are pulled out, the government says, oh, yes, of course, we're keeping those. But the sunset clause means they go unless ministers positively choose to do something. Their choice as to whether to do or not to do something is entirely unfettered by any requirement of consultation or scrutiny or parliamentary control. It's entirely, it's a completely freewheeling executive power. Even if they choose to keep something, they can choose to keep something and then rewrite it quite heavily. They can probably write it quite heavily and probably still have an instrument that only requires negative resolutions. There's no requirement for a parliamentary vote. The quiet boundaries of that slightly unclear. But even in the more and most important areas where they make real changes, what they accept to be real changes in what is actually happening in regulation, all they need is a yes, no, or affirmative vote from each House of Parliament. And the reason why it's the interaction of the sunset clause and the huge powers being given to ministers is critical, is that ministers will be able to say in October, November 2023, if you, Parliament, dare to vote down this quite rewritten regulation on working time rights, which a lot of you may not like very much, but if you dare to vote it down, what will happen is we'll simply have no regulation at all, because the sunset clause is about to hit. So it not only does it use procedures that are in any affirmative resolution procedures that are already an inadequate form of scrutiny, but it adds to that the fact that if Parliament dares to use any of those forms of scrutiny, the consequence is going to be horrendous. So Parliament won't even dare to use the limited weapons that it's got.
So just to put words in your mouth, we're effectively painting the process into a corner. That's what we're doing.
Yes, this. Well, or pointing a gun to Parliament's head and saying, you pass this or else.
Thank you very much. Jill, anything to add to this?
No, I mean, I generally agree with what George has been saying on this. I think we've seen unprecedented use of secondary legislation powers quite a lot under recent governments of the COVID legislation, with the EU withdrawal bill, where we transferred lots and lots of EU regulation onto the UK statute book. That was massive. Parliament responded by putting in place its sifting procedure so that it was able to recommend affirmative resolution for those that it thought were a bit more substantive than the ones that really were just straight transfers. But I think, as George has pointed out, the really interesting combination here is these massive powers, but it's that the default is that legislation falls rather than, you could imagine that Parliament might amend this bill to make the default assimilation. And if the default's assimilation, you effectively achieve what Neil was saying, whereby things are all transferred intact into the sort of new status without Parliament intervening. And I would have thought that that's something like that would be quite likely to be one of the amendments that would be proposed, along with a whole bunch of extra carve-outs as an alternative, in the same way as the Treasury seems to have secured carve-outs for most of the things for which it's responsible, that you could carve out all environmental and employment law if you wanted, and just add to those lists of exceptions. But I think it's that thing. And the other thing is that because that's the default, there's good intent, but there is also just the risk of mistakes, of things just slipping off. We've had this slightly shell shock from the National Archive of finding extra 1,400 regulations that weren't in the government's initial dashboard, but it's possible that the National Archive has also missed some things, and if you discover that in 2024, it's too late. It no longer applies. There isn't a sort of way of sort of reinstatement easily. You would have to take primary legislation to rectify the law and leave a hiatus until you manage to do that.
Yeah, I mean, it might be worth adding to that as the process Jill referred to of rewriting EU legislation to make it work in a UK context, the exercise that took place before Brexit. Every time you look, and I have to look at these regulations pretty frequently in my practice, every time you look at a particular regulation, you find out that there have been 5 or 6 different series of amendments over the period 2018-2019. And that is largely because, as texts were published, people then went through them and realized it hadn't quite been done right, or something had been missed. And so the process was redone and redone and redone until finally Brexit happened. There's no possibility of that sort of process of correction under the new regime, because all of these regulations are going to be one shot. And once they've been made, it's then impossible then to change them once the sunset period has passed. So in that sense as well, mistakes are going to be made, drafting mistakes are going to be made, lawyers trying to interpret their instructions and just getting the wording slightly wrong, or misunderstanding their instructions, or the instructions not getting something quite right on the, as to what happens on the ground.
Thank you all very much. No process for correction. Chair, back to you.
Thank you very much, Jeff. Hilary, over to you.
Charles, thanks. Peter, sorry. Thank you very much indeed. George, a question for you. Clause 1, subsection 2 says that subsection 1, which is says that everything is sunsetted by the end of 2023, does not apply to an instrument or a provision of an instrument that is specified in regulations made by a relevant national authority. Now, does that mean that if ministers choose to lay their hands upon various bits of legislation using clause 1, subsection 2, that they are saved from any sunsetting in perpetuity?
Yes,
right.
That's what it means.
That's what it means, right? In other words,
and not just ministers, also devolved ministers, because relevant,
which is why it says
the devolved government.
Yeah, a relevant national authority. So the way out of the sunsetting risk that we've spent this morning discussing is actually provided for in the bill, provided the minister and or the government collectively decide that should be used. So the get out clause is already baked into the legislation. The second thing I wanted to ask is, can you, and this is to Neil as well as you, George and Jill, can you think of any other example where ministers have sought the power from Parliament to repeal legislation by doing precisely nothing?
No, I mean, I think that's absolutely a fair point. And the sunset clauses that Neil was referring to earlier, I think like COVID legislation, I mean, they're in context where ministers are taking some extraordinary power to deal with some extraordinary situation, and the power comes with it, with an expiry date. And ministers can say, yes, we're taking these extraordinary powers, but be comforted. This will all go disappear
Yeah.
from the statute book. So
Right.
I mean, they're not really equivalent. I mean, one thing, it's just, I mean, you were talking about that. One of the very odd things about the bill is that it's not just clause 1, subsection 2, but there's a separate sunset, sort of rescue from the sunset provision in clause 2, which is different, because that's a power addressed, which exercisable only by the Minister of the Crown, so not the devolved governments, and that but only applies until the 23rd of June 2026. And why you have these two separate provisions is a complete mystery to everybody.
Right. Well, we'll have to dwell upon that. And the third, I don't know whether Jill or Neil want to comment on that at all. And then I've just got one other question I want to ask, which begins to touch on the subject that Alan is going to pick up, who's going to follow me.
I mean, sunset provisions obviously aren't unprecedented, but
Sure.
normally you're debating the sunset provision when you're debating the substantive provision. So you're deciding that you're introducing some tax change or whatever, and and that it will be sunsetted or whatever. So the thing goes as a package. So this sort of retroactive sunset is the oddity, or freestanding sunset, I think, is the real oddity about this. I just wanted to make a point, which I'm not sure I'm going to be able to elaborate in much detail, but I think there are real worries in the devolved governments about their capacity on this. And we talk about the scale of the task for the UK government and things like that. But remember something like environment, most of this is devolved competence. And I think there's real worry there, particularly as they don't have the sort of ability to do the later thing that George was just referring to. I think there's some real worries in the devolved, that even if they thought this was, a great set of powers to have, they just actually don't have the administrative bandwidth. Remember, we don't even have a functioning government in Northern Ireland. The executive has just collapsed, etc. So I think that's another real worry about actually just getting a statute book at the end of this that is in good order.
Yeah.
Okay.
And one sort of technical point, I said that you've got these two different provisions for rescuing from the sunset. The one that's exercisable only by the Minister of the Crown, so not exercisable by the devolved bodies, allows you to describe what you're, instead of listing out each bit of legislation that you're rescuing, it allows you simply to specify a class. So you could say all environmental regulation or something that was written. So that's a power that the Westminster government has. The devolves, however, have to, clause 1, 2 requires you to specify the instruments that you're rescuing. So you'd have, instead of specifying a class, you'd have to say we are rescuing the habitat control of protection of beetles regulations 2020 or whatever it is. You'd have to list them all out. So you have to be absolutely sure that you've got everything.
You've got them all. Yeah. In other words, one potential amendment would be to extend to the devolved the power in clause 2, subsection 1, to extend it beyond just a Minister of the Crown, to include the devolved.
And then if they wanted to, they could simply
specify a class.
Could be everything.
Yeah, it could.
So
Excellent.
Everything within our competence we're going to protect, although of course only under that one until the 23rd of June 2026.
Indeed. So 1, 2 is in perpetuity until you change your mind, and 2, 1 is until 2026. That's the difference.
June 2026, the critical date. Yeah.
Now the other thing that the bill is trying to do is, and I put it in very unlawyerly terms, to say to the court, stop paying so much attention to EU-derived case law.
Yeah.
Although I suspect ultimately judges will have regard to precedent and case law that they think is relevant to the case that is before them. But there is a part of the bill, which is clause 7, subsection 3, that says in deciding whether to depart from any retained EU case law, the higher court concerned must, among other things, have regard to the extent to which the retained EU case law restricts the proper development of domestic law. My question is a very simple one. What is the proper development of domestic law that might be restricted by EU precedent? George.
I mean, it's a very good question, and it's one of those sort of phrases that is almost devoid of content unless you've got a particular context to put it in. I mean, there might be a situation where the sort of EU law sort of marched in tandem, was very closely related to a bit of domestic law that had moved in a particular direction, and it began to look a bit odd to have some difference of treatment of different things depending on whether EU or domestic law applied to them. I mean, it is. I mean, it's very difficult, I think, to give examples. I mean, what's interesting about that list is that it's if you look at the explanatory notes, it says it's taken from a list set out in a case decided by the Court of Appeal last year, which indeed sort of list out factors that the higher courts should think about before departing from ECJ case law. They already have that power at the Court of Appeal and above. But it's it's in fact not a complete selection of the ones that have been.
So it's a partial.
Of the ones that tend to suggest divergence.
Okay.
The other factors, such as continuity of the law, not making major changes to the law without Parliament's approval, those have disappeared from the list, funnily enough.
Okay, that is really helpful. Thank you so much. And back to you, Peter, because Alan's, I think, going to pursue this issue.
That's absolutely right, Hilary. Alan, let's go on clause 7.
Well, I'm not sure if I've got very much to add to sort of Hilary's question. I mean, I guess this was all a great shock to me, but it sounds from George's last answer as if it shouldn't have been. That I should understand that judges have these powers. But I guess I was wanting to explore what exactly does it mean? And I was thinking also, were the constraints on the extent to which any judge could, if he or she chose, diverge from retained EU law? And I suppose, I'd just like it to be explained what it means and how it will actually work, and whether it introduces sort of fundamental uncertainty into the outcome, in the sense that judges now, sort of won't be constrained if they feel like it. I don't know, Neil, you were trying to join in, I think, the previous conversation. So let me start with you.
Yeah, I mean, just before I answer that, Alan, I just wanted to pick up on something that Hilary had asked about. This idea that the devolved nations could be given the same delegated powers to change categories of law. The earlier session this morning, I think, summed it up perfectly by saying, beware of the law of unintended consequences, because by giving the devolved nations that kind of power, you could have divergence within the union. There's already examples of that with the reviews that departments are doing, where some standards apply to England only, but don't apply to the others. So trying to fix that complexity could bring further complexity. But picking up on your sort of question about clause 7, I did have a wry smile about this, because again, back to the unintended consequences, the irony is that this moves the powers of our judiciary closer to the kind of interpretation style that you'd see in the EU, and allows for a more purposive approach. So, there's all sorts of ironies about the whole process we've been going through, but to give the courts more powers and move it towards a more European style of interpretation, I don't believe can have been the intention of the person drafting this, but it is what it is. Also, just picking up on the original written question that Hilary had asked about, is it possible to have a thorough examination of all of this? To my mind, that's a simple mathematical calculation. Putting aside all of the cross-referencing case law and bits that you wouldn't necessarily see, you'd roughly have to look at about 5,500 pieces of legislation in a year. That works out about 15 a day if you work for 365 days. So I guess the question for Jill would be, does she, having been a former civil servant, does she think they've got the bandwidth to do that?
So Jill, why don't you answer that question? But then if you have anything to help me understand clause 7, please do add.
No, I'm going to leave you in the hands of the lawyers on judgments. Just to agree with Neil, though, that stuff that looks like it's saying to the courts, you can sort of make policy in this area, does seem to go rather contrary to the government's more general view that judges are getting too emboldened to do some of that, and the review of judicial review and things like that. But that's much more lawyers' areas of expertise. I think there are real problems with the and Hilary will experience the same about the sort of civil service burden. Because if you think of what you have to do, you have to look at the law, you have to discuss with the minister whether they want to, which of the options they want to exercise, whether they want to restate it, whether they want to amend it, whether they want to just let it lapse. And if you just think about your sort of ministerial intro, remember there is no less work going on while you're doing this. Quite a lot of things going on at the moment. You're in DEFRA, you would put that to probably, the relevant junior minister, there'll be different ones. Junior minister will take a view, you'll do some work as an official. If you want to rewrite it, you need to bring in legal drafting resource to rewrite what you need. You then will be probably going up for a final word with the Secretary of State. So you can imagine if you have the number of regulations that the DEFRA Secretary of State has to look at and consider by the end of next year. I mean, it's very difficult to imagine that they could do anything else. Meanwhile, they are also in a different part of the forest, trying to work out where on earth they're going on their agricultural support scheme, which has the potential to be one of the big Brexit benefits, but is in limbo while it's being reviewed. You still need to set environmental targets under the Environment Act. You've got the sort of day-to-day stuff that you have to deal with as Secretary of State. So it's really, a big international biodiversity conference coming up. There's really a lot of other business as normal going on that you would say probably would occupy your attention much, much better. I mean, I think what was really interesting about this is that in the autumn statement, the Chancellor set out what seemed like a much more sensible approach for regulatory reform, which builds off the Tigger report that the government commissioned from Ian Duncan-Smith, George Freeman, and Teresa Villiers, which said actually don't bother with the backstock of regulations, sort of leave that as it is, target areas for regulatory improvement. Think about what you want to do, where there is a net advantage to the UK from doing something differently, both in terms of the Trade and Cooperation Agreement, in terms of the operation of Northern Ireland Protocol, and probably discuss it with the devolves to avoid some of the issues Neil just raised about going in different directions in areas of devolved competence. Think about how it might interact with your future ambitions on trade policy. And when you decide you actually have identified an area where there is significant advantage of proper regulatory reform, put it to Parliament, have it scrutinised properly, because parliamentary scrutiny ought to lead to better laws getting on the statute book rather than rubbish ones. So I actually am not as convinced as Paul Blomfield was that the government will end up getting this onto the statute book. I think this might lose its way and be superseded by a much more targeted approach, the sort that the Chancellor seemed enthusiastic about last week. He notably didn't mention the retained EU law bill or sing its praises in the autumn statement.
Well, we'll all have to hang on to what little beams of optimism we might have. So, George, can we go back to sort of clause 7?
Clause 7. I mean, I have to say I'm not actually desperately excited about clause 7 because I don't think it actually changes very much, because I said the higher courts already have a discretion to depart from retained EU case law. And actually that is quite sensible, but at least at some level, but that can happen because, as I said, retained EU law is frozen, and it's entirely possible that as the law moves on, it just becomes just not sensible to remain completely stuck with an ECJ case decided in 2020. Indeed, the ECJ might change its mind and decide that its 2020 case was wrong. So that seemed to me to be sensible. I don't think that does very much. I think it's helpful just to sort of think of some sort of practical examples of where all this hits. The sunsetting clause doesn't apply to Acts of Parliament, and a lot of Acts of Parliament implement EU obligations. Large sections of the Employment Act, large sections of the Equalities Act, large sections of the Value Added Tax Act, which I deal with fairly frequently. So they all implement EU obligations. When you're reading that legislation, and if you read cases under that legislation, UK cases under that legislation, it is replete with references to the underlying directives that the acts were implementing, ECJ case law on those directives, principles of EU law that you use. If you're thinking something like the Equalities Act, of course, fundamental principles of EU law are really important to interpreting how that all works, ditto in VAT. Indeed, if you were foolish enough to plan your tax affairs on a sort of cold reading of the Value Added Tax Act and nothing else, you'd be mad, because you'd actually find that bits of it just don't quite mean what anybody would think it means when you see it on the page, because you have to see it against its EU background. Now, all of those acts will stay. The question is, how do you, because they're not affected by the sunset clause, how are you going to read them? What clause 7 does is it says, well, if there's an ECJ case that tells you about the effect of some particular term of VATA, then you might be able to depart from it. So, and the slight change in that. But there are other things going on in this bill that have much more serious implications for how you read those bits of legislation. And those are the bits that remove the general principles of EU law. That's clause 3 in particular, clauses 3 and 5, and what they basically do, they sunset all the background principles that people have used for years to read employment law, to read consumer rights, so take the Consumer Rights Act 2015, which largely implements EU obligations, the Value Added Tax Act. So all of those, so it's not just that clause 7 is in fact of relatively minor importance in all of that, because that's just dealing with the case law. What clauses 3 and 5 do is they remove all the basic principles that you've used for years to understand and interpret all those provisions. Indeed, I think it's because that has really quite substantial effects on how you read these bits of legislation that one finds in the Bayes press statement on this, that tax is going to be dealt with separately. There's nothing in the bill that tells you that, but we're told that tax is going to be taken out. Jill was saying earlier, the Treasury has managed to get its legislation out from this process, and it's certainly going to be able to do so intact. And the reason why is simple. I mean, if you think about the Value Added Tax Act, every day, billions of pounds are collected invoking provisions of that act. Probably not every day, but certainly every month, billions of pounds are collected. If you throw the interpretation of those principles into doubt, you start clogging up the tribunals with case law, and you start prejudicing the collection of government revenue. And unsurprisingly, the Treasury has managed to persuade everybody the tax legislation needs to be taken out of the scope of this bill. But the reasons why it needs to be taken out of the scope of this bill are precisely the reasons why it's a bad bill in other areas of the law.
Thank you. I'm a bit clearer now, so thank you very much indeed. Peter.
Thank you, Alan. We're now going to get, at the end of our session, going to turn to Northern Ireland. Stephen, would you like to put your question?
Thanks very much. Good morning, everyone. I just wanted to ask a couple of questions in terms of relationships between, for the UK with both the European Union and also not just Northern Ireland, but the other devolved nations and regions in relation to this bill, specifically in terms of the EU, the implications around the level playing field obligations and what that may well say for the future EU relationship, and also the wider precedent it may set. And also very specifically in relation to Northern Ireland around the Article 2 of the protocol in terms of the non-diminution of rights. And also just in terms of the devolved settlements more generally. I mean, Jill's touched on the issues specific to Northern Ireland already, but maybe just ask it in a more general sense. Is this bill yet another example of an intrusion into the devolved space by Whitehall, as opposed to a more collaborative approach? And does, for example, the precedent that was set around the common frameworks maybe provide a better model for a more collaborative approach in terms of how this could be taken forward? Maybe start with Jill, given it's very government oriented.
Thanks, Stephen. I mean, in the sense that that devolved governments have powers to use where they have competence. I mean, would the devolved governments have asked for this legislation? I think clearly not. I mean, there's no evidence that the governments of Wales, Scotland, and Northern Ireland are deeply keen. I'm not sure where they've got to on their legislative consent motions if they're doing this. I mean, it does, in a sense, respect their competencies, because it does sort of give them powers, albeit, as George was pointing out, slightly and bizarrely different powers to UK government ministers to do things. So they do have powers in their areas. But if you then look at what will be the net effect of this at the end of the day, the net effect of this is the potential for more divergence and therefore more recourse to the UK Internal Market Act, which we know that the devolved governments really hated, which limits their practical scope for divergence, because it says they basically have to accept onto the market anything that meets the standards in any of the countries. And it also, obviously, where any of the governments use those powers to move away from what is EU legislation, it does also potentially make the workings of the Northern Ireland Protocol, assuming that we retain something that has at least some of the principles at the heart of the Northern Ireland Protocol, does make that more difficult, because every time the UK is moving away, I mean, but as was pointed out earlier, there's a lot of EU legislation going on in the UK Interchanging Europe Divergence Tracker. We track what we call active divergence, so where the UK decides to do something differently from the EU, but there's also a lot of passive divergence going on, where the EU is moving away from the bits of law that we froze in ASPIC as we left and introducing new laws, and we're not following. And we may not be following because we don't agree with it. We may not be following because it's not enough priority for us to give the capacity to do it yet. It may just be that we don't have the bandwidth. Even in Scotland, where they passed their continuity bill, I think they're not actually keeping up with a lot of change in EU law, because they actually don't have the capacity to do it. So I think that, ideally what you would want, I think, for this to be improved would be not to do this root and branch, taking everything off the statute book. Ideally, what you would want would be to identify areas where you think there is a net UK-wide advantage in regulatory reform, and through, whether it's through the Common Frameworks process or whatever, agree what that better reform looks like. There are some areas, I think, where it is interesting to have divergence between the different nations in the UK, because actually we've seen some really quite innovative policy making in some of the devolved governments, which has then, if you like, I think a bit ago, you may not like this terminology, Stephen, but a bit ago, I and a colleague, Akash Pan, wrote something called Devolution as a Policy Laboratory. Actually, there have been some quite innovative policy making in Scotland, Wales, Republic of Ireland, dare we say it, which had then been transferred back, with England as a bit of a sort of late to the party, bit more sceptical whether that was on the smoking ban in pubs, the plastic bag charge and stuff like that. There's some really quite interesting policy transference. And we saw some of that around something where there was a bit of a battle between the Scottish government and the EU while we were still EU members about minimum alcohol pricing. So I think, there are areas where divergence is good, but I think you want sort of, planned and thought through divergence. The big problem with all of this is you get a lot of accidental divergence, where it's actually divergence which imposes a burden, the sort of thing Neil will be worried, divergence by accident on business, because people decide to do things a bit better. Everything's done hastily. You get loads of really badly written laws, which, I think where you're getting these restates, people restate things a bit differently. People are trying to work out whether there's a substantive difference or not. Business has to have the huge sort of burden of working out what on earth government's intent is and whether things really are different or not. So I think, I think this is just completely the wrong way around as a piece of law. That's my fundamental problem with the bill, and a huge amount of time and effort wasted for very little gain.
Sure. Thanks very much, Jill. Appreciate we're tight for time, but with George and Neil, just any quick words from yourselves. George first.
I just don't think of anything to add to that. I just agree.
Perfect. Thanks. And Neil?
Just a very quick one, going back to the law of unintended consequences. I mean, the simple answer to the question you posed is that if this legislation passes, there will be divergence, and we'll probably be in breach of the trade and cooperation agreement. But the unintended consequence that bothers me, both as a lawyer but as a member of FSB, is that it's probably going to impact on every single free trade agreement that we've got, because a lot of the principles of those agreements are underpinned by European standards. So, you know, we've seen after Brexit, a lot of our members are looking to different markets other than the EU, and the FTAs give them a certain amount of certainty. You know, if that's removed and we don't know how we're going to be exporting all around the world because we've suddenly breached all of our international standards, that's going to cause burden for business again.
Thank you very much. Okay, thank you. Back to you, Chair.
Thank you very much. Well, we're nearing the end of the session, and it's been extremely interesting. And we've learned that to be an optimist about all of this, you've got to hope that either the government is only doing it for show, or that actually they'll tiptoe away from what seems to be the worst piece of draft legislation we've encountered in the last generation or so. But rather than leaving it on that very negative note, is there any positive suggestion from any of our witnesses as to what the government should do next to improve what seems to be a parlous situation? George?
Well, I mean, I think I would be open in principle. I mean, I think, as I said, I think when I opened, I think there is an issue with retained EU law that it has frozen in aspect, another quite important in principle and really annoying in practice aspect of retained EU law is a lot of it is actually really quite difficult to find. I tend to find I can only get really accurate versions of some of these regulations by using a private service, which my chambers pays for, but is certainly not open to members of the public. And even that can be quite hard to use. So just tracing and working out what the law is very unsatisfactorily difficult. So I think there's a sort of tidying up case to be made. Whatever one thinks of the prospects of real regulatory improvement here, it just as somebody who believes that law should be accessible and coherent, there's something to be said for going through it and looking at it. And I wouldn't be averse to a bill that gave ministers powers to do large parts of that by statutory instrument. A lot of it is very technical, detailed stuff, which is not really appropriate for debate on the floor of the House of Commons, subject to appropriate scrutiny procedures and mechanisms to make sure that if Parliament does spot a problem, that can be picked up and dealt with. It may be, Jill seems to be reasonably optimistic about it, that we will emerge with some sort of bill that looks like that. It would be quite different from the current bill, but it would be better.
Thank you, George. Neil, would you like to add anything?
I think, you summed it up perfectly in the first session. It's about the art of the possible. If this bill is to progress, I think both sessions have demonstrated that 12 months is not sufficient time period. So, at a very basic practical level, pushing the sunset clause back, there's provision in the bill to push it back to 2026. Still question whether that's enough time, but pushing that back, or as I said earlier in the evidence, turning the sunset clause into a sunrise clause. If the government feels there has to be a deadline, then put the onus on them to actually do the review and consultation rather than risk accidentally losing things because we haven't got the bandwidth to deal with it.
Thank you very much. And Jill, the final word to you.
I think it's an excellent opportunity for Parliament to say that it actually had enough of government assuming to itself massive powers and legislating really badly, and hopefully parliamentarians will use this to draw the line on what they'll let government do.
Well, hear to that from me, certainly. So we've come to the end of our time. I'd like to thank all three of you very, very much indeed for your time today. I think it's been a very interesting session in both halves. we'll try and frame as positive a contribution as we can to put before BEIS and other interested parties. Thank you very much.
Thank you.
Goodbye, everyone.
Thank you. Nice to see
Bye.
you.
Bye-bye.